In the unusual situation where people dealing with a family law case are unable to reach an agreement themselves or with the help of a judge, they may proceed to trial to determine the issues that they cannot agree on.
This video was prepared to give you some information about the trial process. It is divided into two parts. Part 1 provides information on how to prepare for the case before going to trial in a family law matter. Part 2 of this video will focus on presenting your case at trial.
Keep in mind that preparing for court is time-consuming, and it is your responsibility to be prepared.
One of the first steps in preparing your case for a trial is to carefully think through and write down what it is you're asking for and why.
You need a clear idea of the decisions you want the court to make, and you have to be prepared to give clear reasons why. For example, what are you looking for in terms of a parenting arrangement? Why do you think that that parenting arrangement would be appropriate? What are you looking for in terms of child or spousal support? How do you think property should be divided?
In thinking about how you would like a judge to decide your case, you may want to visit the Family Division page of the Supreme Court's website. It has information on the types of orders the court can make, such as parenting arrangements, child support, spousal and partner support, and other information which may be relevant, like links to the legislation and rules that will apply to your case.
Now that you have a clear idea of what it is you are looking for, consider whether there are any areas in which you would be prepared to compromise, or you think the other party might be prepared to compromise.
Settling the issues with the other side puts you in control of the process. When you go to trial, the decision is placed in the judge's hands.
After thinking about what it is you want the court to decide and why, prepare a 1- or 2-page outline of the main points you want to prove in your case. The purpose of this outline is to give you an overview of your case. It can help you figure out what you need to prepare your case, and it can jog your memory during your trial so that you don't forget to present important evidence.
Now that you have your outline, think about the facts the judge needs to know to decide the case. To prove these facts to the judge, you will need to give the judge evidence.
Evidence is information you can show or tell a judge to help them understand those facts. You will need to gather and organize your evidence before going to court.
Your evidence may include documents, photos, materials, objects, testimony, and affidavits. We will now explain what testimony and affidavits are.
An important source of evidence is the testimony of witnesses. Testifying in court means giving spoken evidence under oath.
When a person gives spoken evidence in court, they may only tell the judge information that they know firsthand. This is important to remember, and it means that when you testify, you generally can't tell the judge something that someone else told you they heard or saw. If you want the judge to know what that person heard or saw, you may have to bring in that person to court to testify as well.
Keeping all this in mind, you should think about who might need to testify at your trial as soon as possible. You will have to tell their judge and the other party, or their lawyer, if they have one, who your witnesses will be at the trial readiness inquiry, if one is scheduled for your case. This can be up to 30 days before the first day of your trial. We will give more information about trial readiness inquiries in a few moments.
When a witness is testifying, they give their information by responding to questions. Think about what questions you will have to ask your witnesses to make sure they talk about any topics you will need them to give information about.
By having a written list of questions, you can make sure you don't forget to ask anything important. We will include more information about asking witnesses questions in part 2 of this video.
Talk to each person you want to have as your witness as soon as possible, and make sure they know when you will need them to come to court for you. If you're not certain a witness will come to court for you when they are supposed to, or if a witness is unwilling to come, you can subpoena them.
A subpoena is a document that requires someone to come to court at a specific time in order to give evidence to the court. Only the court can issue a subpoena. You have to have the subpoena prepared and signed by the court well before the court date, and you must make sure the person is served with or receives the subpoena.
You can talk to a court officer if you have any questions about subpoenas by visiting the Contact Us page on our website. Also, you'll need to prepare an affidavit of service for each person you have subpoenaed. The affidavit of service is proof that the potential witness was informed about the date of the trial. A witness will normally have to wait outside the courtroom until it is time for you to present his or her evidence.
While generally the court will require a person to give evidence by testifying in court, sometimes the court will allow or require a person to give their evidence in a written statement called an affidavit. An affidavit is a written statement or declaration of facts that is sworn or affirmed to be true by the person making statements.
The signing of an affidavit must be witnessed by a commissioner of oaths, a lawyer licensed to practice in Newfoundland and Labrador, or a notary public. This means the person making the statement will have to sign it in front of that person. Some court clerks can provide this service, but they will charge a $10 fee.
If you want to present evidence by affidavit, the person who has signed it must come to court in case the other party wants to ask any questions about the statement made in the affidavit.
You may be scheduled to go to a court appearance called a trial readiness inquiry, which will usually be held about 30 days before your trial. At that meeting, the judge may ask questions about the evidence you plan on giving.
The judge may provide information on how your trial will proceed, including directing which persons may testify and which persons might give their evidence by affidavit instead, or make other decisions to ensure a fair and timely resolution.
Before attending your trial, you should organize and review all of your evidence and case materials. Remember to bring any notes or documents you may need. You will need to bring extra copies to court of any documents you want to present to witnesses or give to the judge. Please remember that the information provided in this video is general in nature and should not be taken as legal advice. Representing yourself in court can be a stressful and time-consuming experience.
If you are involved in a case before the court, you are strongly encouraged to consult a lawyer. Thank you for watching. Please visit the Supreme Court website at www.court.nl.ca/supreme for more information.